case briefs, and so much more. LSData's got what you're looking for.
The Vermont Supreme Court heard a case in 2003, Alpine Haven Property Owners Asin v. Deptula, which focused on the reasonableness of fees charged by a property owners association for services it provided. The case also involved the defense of accord and satisfaction, which required a defendant to act in good faith when disputing an assessment bill. The Alpine Haven Property Owners Association filed a lawsuit against homeowners Edward Deptula and Bertrand and Joseph Emmett for overdue fees for road maintenance and other services. The defendants argued that the court made errors in applying certain laws and in dismissing their defense and counterclaim. The original developer of the Alpine Haven development had provided certain services in exchange for an annual fee according to deed covenants. A 1992 court ruling found the fees charged by Alpine Haven Inc. to be reasonable, allowing homeowners to subtract the average costs of driveway plowing and garbage removal. The Vermont Supreme Court affirmed the lower court's judgment against Deptula, while reversing and remanding the judgment against the Emmets regarding the fee structure's reasonableness. The court granted summary judgment for the association on the fee validity, non-members' fee reasonableness, and the FEMA loan special assessment. Furthermore, summary judgment was granted against Deptula on the accord and satisfaction defense.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.